Welcome everybody. Ko Louise Delaney, toko ingoa, no Tax Justice Aotearoa New Zealand. Welcome to our Tax on Tuesday, rather intermittent series of discussions about tax and important issues that are happening in Aotearoa and also in this case today all around the world. We have a guest, an international star here, Andreas Knobel from Buenos Aires. He is the lead researcher from Tax Justice Network International. That's an international organisation of which New Zealand, Tax Justice New Zealand is a member and a partner. Just a tiny bit of background, beneficial ownership, and Andreas will be talking a lot more about what exactly that's all about, but very briefly, it's about who ultimately controls financial arrangements. And it's very timely right now because our rules in New Zealand have been sadly lacking behind the rest of the world. But fortunately, our government has decided in March this year, their cabinet papers are easily findable on MB website by Ministry of Business, Innovation and Employment. The cabinet has issued cabinet papers in March, which indicated that they would go ahead with rules. We, Tax Justice, have put in our own preemptive comments on all of those rules. We broadly support them very much, just would like a tiny bit more detail, and we certainly want them to be applied in a very explicit way to trusts, which at the moment they are not. A bill is being drafted at present as we speak, and we hope that this will be released in September of this year. So this is very topical, and we are indeed very fortunate to have Andreas. He brings a global perspective, obviously, for the entire world, not just Buenos Aires, not just New Zealand. Keen to expose the difference, the relationship between tax avoidance and beneficial ownership. So he's going to talk about what's happening in the world, why this is important, some good examples, and relate what he's saying to the New Zealand situation, on which he has already given us Tax Justice some very good advice. He's an expert, master degrees in law and economics, and he knows all about tax law and public policy. So if I could hand over to you now, Andreas, and I look forward to, as I'm sure we all do, to hearing your presentation. Thank you.
Thank you very much, Louise, for those words. Thanks everyone for joining. Can you see the screen okay?
Yep.
Great. So I'll take my time to try to keep to the 30 minutes. So I tend to speak fast. So if at some point I'm speaking too fast, or if there's something you can't really understand, feel free to stop me and interrupt me. I might not be able to see you because I will be looking at the screen. So just unmute yourself or at least say something to Louise so that I become aware of this. So my work has to do a lot with beneficial ownership registration all around the world. The Tax Justice Network prepares the Financial Secrecy Index, which is this index that covers, as of now, 140 jurisdictions. So among the things that we check for every jurisdiction is whether they have legal ownership and beneficial ownership registration. Legal ownership usually means the immediate holder of an asset or a company, most likely the shareholder. And we check that if countries have legal ownership as well as beneficial ownership for 4 types of different legal vehicles. Those are companies, partnerships with limited liability, foundations, private foundations for those countries that have them, and trusts, both for any domestic law trust, which is a trust created according to the laws of a country, or foreign law trusts that have a local trustee in the country. That is what most of the Global Forum peer review reports based on the OECD standards are checking, and that's one of the main sources we use. So my experience has to do with, after checking all of these laws and then checking, basically my job is to look for loopholes. So we try to we analyze the law of a country and try to find loopholes that any person could be exploiting so as to remain hidden from authorities, and then use the secrecy for whatever, money laundering, tax evasion, anything they might want to. So then we try to explain those loopholes and try to get them fixed. So based on that experience is that we are trying to promote effective beneficial ownership transparency. In addition to that, I have been having a big interest in the issue of trusts because they are even more secretive than companies, even though for some strange reason that I don't fully understand, they're subject to less transparency requirements as compared to companies, even though I find them more problematic. But then trusts have another issue, which is that they have an asset protection feature, which means that even if you had full disclosure and full understanding of the trust existence and all the parties related to the trust, a trust might still be able to shield assets against creditors or authorities. And that's why I think they are especially problematic. New Zealand trusts have been mentioned in the Panama Papers, and I know that there's been an inquiry. I read that inquiry with a lot of interest, and I was quite surprised that just as many common law countries where trusts, I guess, are very popular, the conclusion was that trusts are mainly private family matters, and there was not much need to increase transparency, or not at the level that we would have expected. And sometimes you get similar positions, maybe from the UK, from Australia, or some of the UK territories like Jersey or Guernsey. But it's quite different from the way and the perspective that the rest of the world is taking. So that's a bit of what I will be talking about. So I know that not all of you are familiar with the concept of beneficial ownership and why it's relevant. So I'm going to start with some basic things. I'm also going to have a pointer just to make it easier to follow. So the idea for today, again, I only have 30 minutes. The idea is to then leave a lot of time for questions as well. I felt there were two ways to do this in 30 minutes. Either I try to focus one topic and thoroughly cover it and make it super clear, or try to cover all the points that you should consider so that you don't really get maybe a full understanding of everything, but at least you know that this topic exists. And then you can either ask me questions, or I can suggest more reading material, or even organize another event. So I might go a bit fast, just trying to cover all the things that I think you should be considering now. If there's legislation happening in New Zealand and there's any chance to influence that to make it better, I want to make sure that at least I gave you all of my experience of what are the things that you should be talking about, or making sure that the law will do appropriately. So if that's too fast, again, more than happy to organize another event, or just recommend you reading material or anything else that I can help with. So what is this concept of beneficial ownership? If we had a very simple structure, and that's what we have on the left, where with company one, when the shareholder, in this case Mary, is the direct owner of the company, and there's really no nominee, and she's really the real owner and who ultimately owns that, the shareholder or legal owner is exactly the same as the beneficial owner. And in that case, beneficial ownership is not really that relevant, because, well, we know that just by going to the commercial registry. Now, the situation is that the world is actually way more complex, especially those trying to engage in illicit financial flows, such as money laundering or tax evasion, tax avoidance, terrorism, you name it. So it might be the case that a person or a company is using bearer shares. These are paper documents which are not available in New Zealand, and many countries are prohibiting them, but they're not really preventing these bearer shares from being in the ownership chain. And here the big problem of bearer shares is that whoever holds this paper in their hands, that is the owner. So it's almost impossible to know who the beneficial owner of a company is unless we know exactly who has that paper share, that bearer share at any given time. Another case that might happen is the use of nominees. In this case, the shareholder who appears as a shareholder is just a nominee, someone who is pretending to be the owner on behalf of someone else. I'm not sure about New Zealand, but in many common law countries, nominees are actually legal, and you can have professional nominees that do this for a living. In many countries like Argentina and many civil law countries, nominees are actually prohibited, so that's illegal. But of course, you can have de facto nominees, so informal nominees. It's illegal, but you still appoint your chauffeur, your spouse, or some friend as the holder, given that you will be controlling things. And then you might have, of course, a very long ownership chain, which makes it quite obvious that the shareholder, who is this company, is clearly not the beneficial owner. And at the end of the day, why do we want a beneficial owner? The logic was that, well, if a company is involved in any wrongdoing, like money laundering or tax evasion, we want to find who is responsible and ultimately send this person to jail if they are found guilty. Now, if we only know of some company or some paper, then there's no way to create justice, because even if we find that this company 3 is the shareholder, this might just be a shell company or a company from Panama or Caymans or who knows when, and we have no idea of who's behind it. We get no access, no assets available. So the person doing any wrongdoing would keep doing that without facing any consequences. So the main reason is that we want to know who is really in charge. Now, this is what a world without transparency looks like. And as you can see, everything looks normal. And I realized I have to go way faster than what I was doing. So again, we might have a public tender for an oil contract. We might have a yacht or a house or a piece of art. Everything looks normal. Everything looks legitimate. But it's only once we have beneficial ownership transparency that we can start discovering and revealing any potential illegality or illegitimate cases. In this case, we might find out that actually the owner, the beneficial owner of this company that got the public tender was a friend of the minister, so there's a conflict of interest that without transparency, we had no idea about. It might be the case that this company that won the public tender is also must hire some company from another country, and it is just paying any consulting service, looks normal, but it turns out that the owner of this consulting company is actually the son of the minister. That might be a case of corruption, or it might be the minister himself. Then this person might be putting all this money into Bitcoins or just shifting it around many different bank accounts to engage into money laundering. So using this ill-gotten money, this money from corruption, and then moving it around so as to hide the proceeds and then be able to use it into investing in houses or again, art or whatever they want to do. And that might lead us to another problem, which is asset recovery. Because if we only know, if we start from here and we say who owns this house, and the only idea that we have is that, oh, some company came from Cayman or Panama owns the house, it might be impossible for any authority or a journalist or an NGO to find out who is behind this company. And then we would never be able to recover all the assets and corruption that was stolen. Now the world is actually seeing this, and at TJN, we have been talking about the big role of countries like the US, Germany, the UK, Japan, in creating this financial secrecy. And it's now that they realize that all the secrecy that they created is actually preventing them from enforcing sanctions against Russian oligarchs, just because they actually don't know what Putin or what any other of the oligarchs actually own. Because of course, they're quite smart people and they don't own assets under their own name. They use, again, many types of companies or trusts. So this lack of transparency is now creating a lot of trouble even to impose these sanctions. It might be the case that we have a charity, and just because it's a charity, it sounds great, and it might be doing great things, and they might even appoint the Red Cross or UNICEF or whoever you want as a beneficiary. That doesn't mean that any of the Red Cross will actually get $1 from this charity. What might happen is that this might just be a front for terrorism financing. And lastly, just to make the point that it's not only about these major financial crimes like terrorism or tax evasion. Sometimes even this is relevant for society and investors and the private sector. And it might be the case that with beneficial ownership transparency, we could realize that there was just a case of bid rigging. And where it looked like a competitive tender, it's actually all of them are owned by the same person. So there was no real competition. This was in a way illegal. So the point is that with transparency, once we really find out who is the ultimate beneficial owner, we can be revealing or at least prosecuting or investigating many of these crimes. If we only had the first layer, so this company, that's the only thing we know, of course, everything would look legitimate and fine. So how is beneficial ownership BO around the world? So there are different standards and there's different, in a way, pressure to do something. So on the one hand, we have the FATF, and they have the recommendations on anti-money laundering and financing of terrorism. We have the OECD's Global Forum that has more of a tax perspective. And you might have heard of the EITI, the Extractive Industries Transparency Initiative, which has a focus on extractives dealing with mining or oil and gas. A lot is happening right now. The FATF, which is this body, highly influential in most countries. It is reforming Recommendation 24, or actually reformed already. It has already approved this recommendation reform. And that means that Recommendation 24 has to do with beneficial ownership for legal persons, such as companies and partnerships and foundations. And since the reform, which happened in March of this year, all countries are now required to set up beneficial ownership registries or some equally efficient alternative mechanism. Most likely, we think that most countries will really set up a register. And the FATF is now undergoing the reform of Recommendation 25, which deals with trusts. And again, with trust, they're not going as far. And I think it's very unlikely, even though we are trying to put pressure there, to ask for trust registration, even though we think that's the way it should go. Now, based on our research, and I said that at TJN, we cover, we assess all these countries, I mean, all those that have a color, which is not light gray. So based on that, these are the countries in blue that have some law requiring beneficial ownership to be registered with a government authority. And as you can see, the European Union is most advanced, but Latin America is following. Australia and New Zealand are quite behind. This is not updated. I mean, as of now, it's better. So the US approved its law in January of last year, and more countries like Nigeria and Tanzania are also working on this issue. So we really see, I think like as of now, we have 90 countries moving here, and hopefully New Zealand will join these countries. Now, what are the key points where you have to be very, very careful so as to prevent big loopholes? So one thing has to do with the scope. So there are many types of legal vehicles, and by legal vehicle, I mean anything different from a natural person that could be covered. Most laws will cover legal persons only, and I think that is where New Zealand might be going. So it only covers companies and other legal persons, but leaving trust apart and not covering them, not requiring trust to be registered. In some cases, I'm not sure how LPs are treated in New Zealand. In the UK, LPs are not considered to have separate personality, and that means that LPs were not covered by the BO registration in the UK. There was a big scandal of many Scottish LPs being used for the Russian laundromat. So as of now, Scottish LPs have to be registered, but LPs from England and Wales or Northern Ireland are still not required to register their beneficial owners. So as long as you keep one loophole, that of course will be exploited. And we've seen how registration from Scottish LPs went down, but then registration from Irish and Northern Ireland and England, Wales LPs went up. Because again, people will rearrange their affairs to keep exploiting all the secrecy that is available. Another point, once you define who will be covered, if it's companies, trust, or everything, is what is the connection point? In most cases, that is local incorporation. That is, any New Zealand company will have to register. Now, the question is what happens with foreign companies that operate in New Zealand? Will they have to register or not? Some countries might say, well, if it's subject to tax, they have to register, or if they have assets, maybe real estate, or if they have a local participant, that might change. But again, most countries get it wrong and only cover local incorporation. And then you might have limitations to the scope that even though companies might be covered, you might say, well, but only the main taxpayers will do it first, or there will be an exemption for listed companies, companies that do not stock exchange, or investment funds. This is what happens in the EU, the famous Anti-Money Laundering Directive 5, which is one of the at the vanguard of transparency. In the case of companies or legal persons, the trigger is incorporation. For trust, no. If it's a trust created according to the laws of an EU country, no need to register according to the directive. Now, in the case of trust, what matters is whether the trustee is located in the EU, and there's no equivalent for companies. So if the CEO or the director is a resident of in the EU, no need to register a company. In the case of a company, it's only about incorporation. For trust, if it acquires real estate, not if it already holds it, or if it establishes business relations, they have to do it as well. This is not for companies, although the EU is now discussing the AML package where they might also apply this to legal persons. And then the big difference was that for legal persons, the BO registry will be public, and most countries are even giving public online access. But in the case of trust, it's only with a legitimate interest. So we have to be very careful when countries said, like the EU, said these differences and let trust to be even subject to more secrecy than companies. Other point is that, again, the typical BO definition will say something like the BO, the beneficial owner, is a natural person who ultimately owns and effectively owns or controls an entity. In principle, anyone having more than 25% of the shares, maybe also the votes. If not, let's find someone with control via other means. And if not, let's just appoint a senior manager like the CEO or some nominee director as a beneficial owner, which is very problematic. So the things that you have to be looking into is that what are the prongs or the elements used in the BO definition? Ideally, it would cover anyone with control or ownership or benefiting from a legal person or a trust. But again, many just focus on control. Is there a cascading test? So first, like that's what the FATF says. First, check someone that meets more than 25% of the shares. If someone does that, don't look for anyone else. Or ideally say, well, no, you have to check either you have more than 25% of the shares, or maybe you have the votes, or maybe you have control via other means. So I will check everyone that has at least one of these criteria instead of only stopping after the first one I found, which is what the FATF and many countries are doing. Most countries will say, well, 25%, but it's either direct or indirect, not just direct. But then do you apply the threshold to each level? That is a discussion happening now at the EU. Thresholds, and again, most countries use this more than 25%. That means that if you have a company with 4 shareholders, no one passes the threshold and none of them will be identified as a beneficial owner. And that's the easiest way to circumvent this. That's why we're against thresholds, or if you're going to have a threshold, it should be as low as possible. And some countries like Argentina and Ecuador and Botswana, they don't apply any thresholds. If you have 1 share, you already need to be identified as a beneficial owner. And we say that if you're going to keep the FATF definition, and if you can't find anyone, you appoint the senior manager, there should be a big warning in the BO register saying, hey, this is just a senior manager. Don't confuse this with the real BO. So even though it says John is a beneficial owner, there should be a warning saying this is just a senior manager. The company couldn't find any beneficial owner, and that's why they just appointed this. And that creates a warning for users like banks or even authorities being like, well, this company might be subject to more secrecy than any normal company. Now, what I try to make here, the point is that, again, the scope and the BO definition will determine how many people will actually be identified. And of course, what we want is as many people as possible. Because if you're trying to look for the wrong persons or like oligarchs, Russian oligarchs, you want to have information about more people. If you're in this case, you will actually not get anyone registered. So the first filter is the scope. You might be covering all legal vehicles, so both companies and trust, or only legal persons. If you're here, the trust, you forget about it because the definition, the law only cares about legal persons, so basically companies. And then based on the definition of the BO definition that you have, say if it's more than 25%, none of these 4 people will be identified. And if you actually had no threshold whatsoever, or like say a lower threshold, then you would get all of them identified. This is just showing that whatever you define in the scope and whatever you define in the BO definition will determine how much data you will end up having. So the wider the scope and the wider the BO definition, the more people you will get. But if you get it wrong here, you might actually not get the data at all at the beginning. And this is what even gets to be registered. Then we have an issue of enforcement, verification, access. So even if you get it wrong this way, it will be much harder to in a way improve it later on. So other issues that you might have to be aware of. What happens when there's a combination of trust and legal persons? In the case of trust, the FATF and the EU directive are quite right to say all parties of the trust, the settlers, all trustees, protectors, beneficiaries, everyone has to be identified no matter what threshold, all of them have to be identified. Now, what happens is that if you put up a company in between, so now the beneficiary instead of a person is actually a company, you might have the case that now thresholds apply because you would be using now the BO definition for companies. So in this case, people directly own the trust, are beneficiaries to the trust, all of them have to be identified. If now they are shareholders of a company that is a beneficiary, now none of them has to be identified just because we would be applying thresholds. So these are some of the risks that might be happening. The other one, again, is bearer shares. They might be prohibited in New Zealand, but if you don't prevent, say, company 1 or company 2, which owns a New Zealand company, to have bearer shares, you will still have the secrecy from bearer shares affecting New Zealand. Basically, the bearer shares are up in the chain, but still affecting you to prevent to know who the beneficial owner is. And of course, the issue of nominees. So then the other things that you have to think about, and many legislations on even the FATF will say, well, we need timely access to precise and accurate and updated information. What does that mean? You need enough identification details on each beneficial owner, a tax identification number, a national ID if the country has it, a date of birth, place of birth, residency. This can change because of golden visas. Some countries ask for the politically exposed person status because that might be an indication of corruption or a high risk of corruption. Again, there are many things that you could be asking for, but clearly it's not enough to have full name. And that is, for instance, what the UK asks for legal owners. It's only the full name, but there can be thousands of John Smith in the UK, and well, you can't differentiate between the two of them. It's important how frequently you have to update information and the issue of verification. Global Witness did an amazing job. It's an NGO. They checked, given that the UK register, the BO Registrar is public, they checked the data and they found out that there were like 500 different ways to write the nationality British. So from there, imagine all the things that went wrong, people writing the BO is Mr. X, last name Y, or I don't know, Hitler, I mean, like crazy things, or Mickey Mouse, they were just writing whatever, and no one was checking that. So clearly the information was not precise. So it's very important that you try to set up some kind of verification mechanisms when you set up a register. It's not just about accepting anything, letting people register whatever they want. Access, this might change. Some countries only allow competent authorities. Some countries also allow obliged entities like banks and lawyers, and then they ask them to report discrepancies. In the EU, for trust, it's the legitimate interest thing, but ideally we will be looking at public access. New Zealand already has public access for legal owners of companies, so it would be great if the BO register will also ensure public, online, and free access. But these are the questions. Is it free? Is it online? Is it structured data? Is it in open data? How can you search for information? Only by entity name, by the beneficial owner's name, by the beneficial owner's residency, so that, say, Argentina can go to the register and check all the Argentine beneficial owners that have a company in New Zealand or a trust in New Zealand, and that's what would be relevant for Argentina. So the more structured the data and the more search fields, the better it is for NGOs, journalists, and foreign authorities especially to be able to use your data. And that's why, given that we live in a quite globalized world and where New Zealand has been mentioned in the Panama Papers being as a destination to set up offshore entities just because it has a good reputation but still enough secrecy, I think it's time for New Zealand to really catch up with the moral transparency side of things. Now I have 6 minutes to talk about trust. So I think, like, being in New Zealand, you are all very familiar with the trust concept. Actually, that's not as common in other countries. But now what might be different between different countries is whether the trust exists as an entity or similar like as an entity, or if the trust itself doesn't exist, it's not a thing, and the only thing is between the settlor and the trustee and the beneficiary. So it might be that the settlor gives assets or cash or a house to the trust or directly to the trustee, who has a fiduciary duty to use and manage the trust assets to benefit the beneficiaries. That is the whole point of the classic idea of a trust. And there's this idea that it started in the UK, and in England, at least in the Crusades. So the settlor was going to go fight in the Crusades. He wanted to make sure that the land would be used for his wife and children. So he would appoint a trustee to hold the land and make sure that he was using it in favor of the wife and the children. Now that's the idea. So where we have three different parties: one settlor, the father, the trustee, a lawyer, the brother, and then the beneficiary is the wife and the children. Now, in many offshore jurisdictions, there's nothing requiring you to have three different people. And actually, all of them might be the same person. Or they might not be the same person, but it's very hard to tell that they're not the same person because these might be companies. So it's very hard to know who is behind that company. So the main secrecy problems of trust is that in most countries, and that's not everywhere, but mostly in common law countries, they don't need to incorporate or register in order to exist or to have legal value. And that means that many trusts might exist, and we have no idea how many exist, the assets that they hold, or who benefits from them. It's a huge, we're completely ignorant about that. There was a report by the Australian Tax Administration in 2019, where they were looking into the trust and they saw they have a huge problem. And they said, in essence, trust registration in Australia is based on a self-reporting system. And that, of course, creates quite complex a set of challenges. Basically, they cannot know how many trusts exist. And they say, by comparison, the corporate structure is heavily regulated in Australia. And even though trusts are widely used, not the same type of registration or supervision. Now, this lack of registration encourages opportunism and fraud, and they give these examples. So there might be an allegation that the trust exists and have certain terms that may be based on falsified documents. They never have to be registered, so who knows if they are real or not. Or just simply change things whenever you have a tax audit. Because again, if it hasn't been registered, no one saw any of the documents, you can just say, hey, this is what happened last year, or this trust, you can just backdate it or do whatever you want, because authorities never had access to the data in the first place. Again, this is the basic trust concept. This is what might actually happen or be involved in a trust. You might have the legal settlor, who is the person who actually appears on the trust deed, which is different from the economic settlor, the one who's really giving the money into the trust, even though it doesn't appear anywhere. Now, the most sophisticated cases of secretive or asset protection trust tend to use this discretionary feature, saying that it's a discretionary trust, where the trustee has discretion. And again, the trustee might just be a company, where the directors of the corporate trustee are the ones making the decisions. And it might be the economic settlor. We don't know, especially if we don't have BO registration for this company. We have no idea who is behind it. And the protector is usually used to make sure that the trustee will do what the economic settlor wants to do. But now the good thing for transparency, the bad thing of discretionary trust is that they might say, well, there is no real beneficiary. So I'm not going to identify anyone yet because none of them may end up being a beneficiary. So all of them are potential beneficiaries, but it will be up to the discretionary trustee, to decide using my own discretion who gets a distribution, when they get it, and how much. And if I decide that none of them get any, then none of them will be a beneficiary. And they use this so as not to have to identify beneficiaries beforehand. It might be the case like in the Isle of Man, where we have purposes instead of beneficiaries. So there's no beneficiary whatsoever. We only have a purpose. Or it might be the case that we don't name a beneficiary, but we do indirect distributions. And so we pay for someone's credit card consumption, or we pay for someone's education fees. So that's an indirect distribution, which is very hard to detect. So again, trusts are so complex because in addition to all this complexity, again, they don't even get to be registered. So authorities might not even know that these exist, or might not even have data about all these people, because these tend to be secretive documents. Many times we find out about trust, in most cases, if there's a big investigation that got into one, or if there's a divorce case, because in that case, the spouse, most likely the woman, is being ripped off by the husband, and so she goes to the media. Again, we're talking here about most cases of millionaires where this happens, and that's how we find out about the trust existence. Now, the main thing about trust combined with companies is twofold. On the one hand, and this is very relevant for New Zealand now, even if New Zealand will not have a law requiring trust to register their beneficial owners, it's very important to know what happens when a trust owns a New Zealand company. Who has to be registered in that case as a beneficial owner? Because of course the trust is not a person, so the trust should never be, a company or a trust should never be a BO. So the question is, if a trust owns, or the trustee on behalf of the trust owns 100% of the company shares, who has to be identified as the beneficial owner of the New Zealand company? Now, the right answer to that should be all the parties to the trust. We should apply that rule. So all the settlors, protectors, trustees, and beneficiaries should be identified. Not all countries do this. So some countries might say, well, it's only the trustee and any other person, or they might not say anything about that. But it would be relevant for New Zealand to really define what happens if a trust owns a company. Ideally, New Zealand will change their law and will also cover trusts to requiring them to register the beneficial owners. But in that case, again, it's important to know what happens when we have parties to the trust that are companies or legal persons. And this is what I'm trying to show here. If this person has only a right to 1% of distributions, and this corporate beneficiary has a right to 99%, it might still be the case that only this one gets to be identified and registered, but none of these, just because they're using a company. So it would be really good for the law to have provisions about what happens when there's a complex structure like this one. I'm almost done. So this feature of asset protection trust, that many people are not aware of that. So this paragraph has, it's so relevant that I'm just gonna read it here. And this is from a Harvard Law Review paper from, I think it's like the 60s or the 70s. So it's not like a new thing, it's been going on for decades and still not much has happened, but it's basically, trust can also pass use and enjoyment of wealth onto beneficiaries while shielding the wealth from the beneficiary's creditors and from judgments in divorce. If you don't own it, the saying goes, nobody can take it away from you. All of these benefits can be coupled with essentially complete control allocated according to the guarantor's wishes. This makes the total package effectively indistinguishable from property owned outright in terms of the benefits provided, but without the important downside property ownership entails, such as exposure to taxes, creditors, or eventful ex-spouses. So basically what this is saying is that with a trust, if you're the grantor or settlor, you get all the good things about owning, like enjoying an asset, but none of the bad things of owning things, which is none of the creditors can use that or can access that to repay any of the debt. And this is especially efficient or effective in a discretionary trust, because this is what happens. If any of these have a personal creditor, the settlor, the trustee, or the beneficiary, the settlor will say, well, I know you're my creditor, and let's imagine all of them are insolvent. He will say, I'm sorry, but the asset is no longer mine. I gave it to the trust or the trustee. The trustee in turn will say, well, it doesn't belong to my personal wealth. I might be the legal owner. It's true. The assets might be under my own name, but only as trustee on behalf of the trust, and they're only to benefit the beneficiary, not me. And then the beneficiary will say, true, I might be named as a beneficiary of the assets, of the trust assets, but they're not mine yet. I need to wait for distribution. This might happen when this person turns 21, when this person gets married, or again, only when the trustee uses their discretion. And many of these trust deeds say, well, never, ever give a distribution to a beneficiary who has creditors or who is bankrupt, so as to make sure that the money will never get in the hands of those creditors. So what are our recommendations? And I will finish here. Ideally, to have a central BO register, and I think New Zealand is going in that direction, to have the widest possible scope, so ideally cover all types of legal vehicles, companies, partnerships, trusts, or foundations. I understand that New Zealand will only cover companies and maybe partnerships or legal persons, but not trusts. The widest possible trigger, that is, of course, incorporation or a trust being governed under New Zealand's law, but also cover any foreign asset, any foreign legal vehicle that has assets in New Zealand, not only real estate, but any type of registrable asset, local participants, not just a trustee, but if it's a beneficiary, a settlor, or a shareholder. The BO definition, having ideally all elements, ownership, control, and benefit. Most likely, I think New Zealand will only cover these two, following the FATF, and at least try to use the lowest thresholds, or ideally no threshold at all. Provisions for complexity, what happens when trust and legal persons are combined, prohibiting their shares throughout the ownership chain, ensuring public access, free, online, and open data. Again, the current online registry of New Zealand for shareholders of companies is quite good, so hopefully the same thing will be used. Ensuring also some verification mechanism, all cross-checks, again, the tax administration's information, the natural persons register, any other database that the country has, ideally automation, red flagging. I mean, we have a whole paper on verification, so happy to cover more on that. And ideally also sanctions. Many countries might get these rights, but then fail on the sanctions. And the only sanction for failing to provide a BO or giving the deliberately wrong information might be pay $100. And it's like, yeah, happily here, I'm gonna lie to you and only pay $100 and that's it. So ideally it will be like prison sentence, like in the UK, big fines based on a percentage of income or just a high value, like say $100,000. Or even ideally what we want is suspending the tax ID numbers so that this entity cannot operate in the country, but even better, to directly not allow the registration of this company or trust, or even to remove it from the register if it already exists. So that is what we think to be the best sanction possible, so as to make sure that entities will not be misused. And according to the FSI, the situation in New Zealand is that, again, it's very good. They have a very good public access to legal owners of companies. There is no BO registration. There is no public access of legal owners of limited partnerships. Basically, there is no public access of limited partners. It might be good if New Zealand is going to reform things to also improve this part. And then I've checked trust registration laws of more than 100 countries. New Zealand is one of the most complex ones. It's almost impossible to understand what happens. But based on some assessments by the FATF and the Global Forum, my understanding is that there is registration if it's a local or foreign law trust, so depending on the governing law, and it's non-charitable, as long as there is a local trustee in New Zealand, a local settlor, and the trust has taxable income, or this famous New Zealand foreign trust, which might be a local or maybe a foreign law trust. I couldn't even find a good definition of foreign trust in New Zealand's law, that has a local trustee, a non-resident settlor, and where these provisions of Article 59B from the tax, the Transparency, it's like, no, the Tax Administration Act, I thought it's the TTA. But it's not even clear to me, based on even what the New Zealand Inland Revenue says, if it's that they always whether they always have to register, or if it's only when they want to be exempt from foreign income tax. So I wasn't entirely sure of that. And so I know that New Zealand changed their provisions recently after the Panama Papers, but even then, many trusts that were registered decided not to re-register, indicating that many people are using New Zealand trusts not really for good things, but more for the secrecy side. So ideally, they would be covering all trusts. And well, I will stop here. Thanks.
Well, thanks for that. And I hope, Andres, you'll be able to make your presentation available to us for those who want to pore over the details a little bit more. Thanks so much. Well, that was it was a lot to take in. I just have one minor point of clarification, and then I want to ask a rather big question, and then we'll wait and see what other people have to say. First of all, just in terms of a minor point of clarification, the Cabinet Papers that were released in March in New Zealand did say that the rules apply to beneficial ownerships involved in trusts, but in a very unsatisfactory way, in our view, in the sense that there is no formal complete register of trusts, as you have said. So it relies on, to an extent, on people involved in trusts putting up their hands and saying, yes, yes, I meet the beneficial ownership criteria. Now that's as the proposals were in March. I don't know if that's going to be what it's like when the exposure bill, the draft law comes out, but there is that reference to trusts. However, in our view, Tax Justice's point of view, it is extremely unsatisfactory because there is no information out there about trusts, and so therefore no way of finding out whether the information is whether people are saying what the story is. So that's just one point of clarification as far as my understanding goes. My second question is a rather bigger one and perhaps completely beyond the scope of your outline, though, of transparency and risks, complexities in relation to trusts makes me think, well, why are we trying to band-aid, in a sense, all the deficiencies in trusts? Why don't we just abolish them? Now, that may be a totally ridiculous sort of thing to say, seeing they're so embedded in our law and society. But is what is needed, apart from beneficial ownership in the meantime, a truly thorough, radical, and thoroughgoing question of why we have these trusts, which are set up for some good purposes, but have been misused over the years, and now, generally speaking, are not used for positive functions in society, or at least only to a limited extent. So with that, that's a very mind-blowingly big question, a bit beyond the scope of all of this. But if I could just ask you for your comments on that before we turn to some more specific questions.
So I completely agree with that. And I think like some people are saying like, oh, you just want to abolish trust. And it's like, not necessarily, but the main argument in favor of trust that I've heard, and especially from STEP and trust and trustees, is that they say, well, but again, a person is worried about their children, or they have like some family member who has like some disease, and they want to make sure that after they're gone, someone will take care of them. And I think that's a great argument. And I think that it's very possible, but there's nothing in the trust law that requires beneficiaries to be sick people or vulnerable people or even children. So that might be a great argument, but many times what happens is that, again, using this great argument, we see people who are, it's a self-settled trust where they might even like appoint their wife and children as beneficiaries, but then they get the distributions themselves. So many times it's misused. So if the law were to say trust can really only be used when a judge confirms that the beneficiary is just the children or this person who is vulnerable and has some sickness and should be, I would be more in favor of that. But currently, just based on that argument, we're allowing any kind of person to benefit from trust. And many times we have oligarchs who can just avoid sanctions because they have in a trust, people who embezzle money. I mean, I didn't have enough time to go into all these cases of really abusive uses of trust. But in the US, there are cases, and it's not, because sometimes people will say like, well, that's a really abusive trust, but that would never stand in court. Now, there was a case of a person who committed 90 times for sexual abuse against a minor, was sent to prison, but then this person was also a beneficiary of a trust. When the mother of the minor sexually abused tried to get money, like an indemnification in civil court, they said, sorry, all the money's in the trust, you cannot touch that. So unless there's some trustee willing to give the money to the beneficiary, so then you get it. Otherwise, the money is safe in the trust, even though this person had been convicted of sexual abuse. Another case of murder, the same thing happened. People tried to rob a house, they ended up killing the woman, and then the state sued them, they went to jail, and then they said, sorry, there's no kind of way to pierce a trust just because of tort creditors like victims of murder. It's only for the people that are allowed according to the trust law. So we've seen that, and then there's investment case of Jersey. So many cases where trusts are so abused, and I honestly don't understand why society keeps that. Some people say it's too complex, or it's so traditional, it's been centuries in many countries, laws, or it's like just centuries old in England, that why would they get rid of such a basic instrument? It's like, even if we don't abolish them, let's put some measures. If you really think the main argument is to protect vulnerable people, well, then only allow that for vulnerable people and not just for a self-settled trust. And again, many times trusts are used for this asset protection feature, but also for the secrecy side, just because if they're not registered, you might say, well, you have to register with the tax administration just to get some tax benefit, or just because you have to. But now if you don't do it, how do they ever find out? I mean, in a company, you register, you have an incentive to register in many cases, because otherwise the entity doesn't exist, or you don't get limited liability. So in some countries, if you have a company but you don't register it, you are fully liable. In the case of a trust, you're still allowed all the rights of the trust, even though nobody even knows of the trust existence. And there's all this case of offshore and how all these strategies just to make it impossible for creditors to ever get the money. Even if they are right, it will take them so long going to Cook Islands and New Jersey and all these places that they will never get their money at any time soon. And the question is, why do we allow such an abusive regime? Even though there are good cases that could be used, but the law is allowing all uses, not just those very good uses that could be used for. So yeah, I agree with that view. And so our proposal was that trust should be something like a will. In a will, you can say, after I die, I want this house to go to this person, the car to go to this other person. And that's like, great, as long as when you die, you still have those assets. If you lost those assets, well, that will is worth nothing. Now, so a trust should work, from my perspective, in the same way. You can be promising whatever you want, but the trust should not, assets should not be in a limbo. Either the settlor owns them or the beneficiary owns them. It's gonna be like, oh, no one owns them. We can all enjoy the house, we can all use the private jet, but not on paper, no one owns them. It's like, no. The law should say if you are insolvent and you have a creditor, one of them has to own it, either the settlor or the beneficiary, but one of you has to own it. So those are some of the provisions, and we have, again, many papers. For all these things I've said, a lot has been written by us, so I'm happy to share all this material. I know that half an hour or 1 hour is clearly not enough to cover all these issues, but yeah, happy to now to take.
Well, I can certainly see, that, another sort of, once we've got beneficial ownership done and dusted, then I certainly think a focus on trust myself would be a good focus for us in Tax Justice Aotearoa. I just wonder if you could just spell out just very simply, and I know this is you've hinted at these various issues, but so we are not thinking of having a register of trusts per se. That's the New Zealand position at the moment, as far as I understand it, although we hope to change that, but at the moment that is not what is being proposed. We may have some indirect reference to beneficial ownership, but I'm not sure how that's going to pan out. I'm certainly not sure how it's going to work. Can you just sort of spell out in words of one syllable? I know no academic is familiar with that concept, but never mind. What are the specific risks, the dangers that we in New Zealand face if we do not have a register of trusts?
I mean, I would say that basically you cannot prevent trusts from doing any of the illegal stuff that they might be doing. And it's not just New Zealand. I mean, the thing is that New Zealand being so much used by other people, I mean, people from other countries, it's not only risk for New Zealand people, but also like you would be almost like any tax haven, just allowing people from all over the world exploiting. I mean, I remember I used to work at a law firm in Argentina, and the person went to New Zealand just to train on how to offer New Zealand trust to elites, rich people from Argentina. So I'm sure that this doesn't happen only in Argentina, but people from all over the world are trying to exploit New Zealand just because it looks fine. It's like, again, reputable and stuff. So basically, if you don't have a register, that's the thing with a company, with the trust, with anything. It could be used for the good things or for the bad reasons. Terrorism, tax evasion, money laundering, you name it. If you have no idea about that trust, it could be used for all of those. So basically, you cannot prevent any of that unless you know that the trust exists and who's behind that.
Okay, thanks. Now I've got a question here. from Keith Ng. Thank you very much, Keith. He was one of the journalists who worked on the Pandora Papers for the New Zealand Herald, one of our papers here in New Zealand. So Keith asks, are disclosure, a practical question really, are disclosure requirements for offshore structures effective? If it's a complex structure with significant offshore components, can tax authorities know when they don't know?
So, I mean, I think like if these journalists work with them, I feel like leaks are the best example, like Pandora Papers, Panama Papers, that if we had information, we would be able to determine all of this. Without real information, that's a problem. Like the moment, I've also like, I'm working out complexity, and the moment you have one layer in a tax haven without a public register or without a register whatsoever, then it's impossible. And that's what authorities say to you. I mean, even if it's the first layer that ends in Panama or Cayman, then you're done. There's no way to know. So unless, I mean, you can ask Cayman for the information, but of course they will ask the resident agent. There could be all these risks of tipping off because their business is basically helping people remain hidden. So without transparency, there's really no way to know it. So I think like that's why leaks are so important. Now, when you at least start requiring the full ownership chain, and that is what some countries are doing, like Belgium. So in Belgium, when you register your company, you have to disclose all the ownership chain up to the BO, then you have some way where to start. Because then we have this idea of a complexity, and we tend to be on the radical side. So I feel like maybe our ideas will be taken on maybe 10 years from now, but from now they're still taken too radical. But what I say is that, hey, if I wanted to sell a car in Europe or New Zealand without seatbelts, the country would say like, no, sorry, you can't do that. I mean, like either you abide by basic safety reasons or you cannot sell a car. But now when it comes to owning an asset in the UK or New Zealand or anywhere, there's no restriction about how complex that ownership chain is. It can be like Cayman bearer shares, and everything is permitted. And the question is, why do we allow that? I mean, if we don't allow that if we think it's unsafe to sell cars without seatbelts or you name how many other things, why do we allow complex ownership chains, or even if it's not complex, even if it's just one layer from Panama with bearer shares, that should not be allowed to own any assets in New Zealand. And that could be very easily established in the law. So we at the FSI, the FATF, there are many sources of saying these are the countries that have a public register. So basically any entity from those countries should be fine. I mean, authorities will at some point be able to get access to that. But if it's from a country that is highly secretive or a country with bearer shares, why do we allow that to be in the ownership chain of a local asset or like a local company? For me, it's obvious it shouldn't be the case, but again, many times it's more like countries want to promote investment and they want to create jobs and they don't want to affect the economy and they don't want to be the first ones doing that. So in the end, it's almost, I mean, I feel like 10 years ago, we could go to a bank with $1 million in cash and open that bank account. Now, in principle, that shouldn't happen. Yes. And I hope that in the future, there will also be more restrictions about, again, you cannot just do whatever you want in the ownership structure and just go to tax havens just to then, because basically, I think it was also the UK when they were discussing the overseas entities bill. This law to require foreign companies to disclose their beneficial owners when they were going to acquire real estate in the UK. Okay. And there was one question.
Yeah. Sorry to interrupt there, Andres. We haven't got too much time yet. Okay, I think, Keith, that is a great question. And my own personal response as well is that it's not just beneficial ownership that we need when we talk about transparency, it's disclosure and registers of assets as well. But that's a whole other topic. Perhaps, I'm afraid we've only got a few more minutes, and Paul Barber asks a question, and I'm not quite sure, Andres, whether you would be in a position really to know. Paul asks, why did the review of New Zealand trusts, what did the review conclude following the Panama Papers? And why did it say that most trusts, in quotes, are for families or legitimate purpose when they can't know it? So that might be a question that's a bit beyond you, Andreas, and that you don't know why on earth the review of trusts concluded such.
Yeah, I mean, actually, I remember, like, it's not like I read it yesterday. I read a few, I mean, it was a long time ago, but it said something like, to me, it made no sense because it was acknowledging all these risks of New Zealand trust, but then it simply said, oh, but by the way, here, they're mostly used for private family matters, so there's no need, and it will be create all this cost and all this burden, like, we shouldn't go there. But almost like taken as a fact, like, no, they are fine. We know they're fine. Those are just, I feel, red apples, bad apples. Like, to me, it made no sense how they concluded that based on the facts that they were describing, but that's what they did. I mean, the inquiry is public, so I think anyone can look at that.
Okay, look, thanks very much. We do have another question. I'm sorry, we can't quite, but I think from Robert Clark, who asks, what arguments do people who oppose transparency use and why are they wrong? I think that's pretty clear it's come out from a lot of what Andres has presented. So could I just sort of conclude really here, and I'm sorry to cut off anybody else who has questions, conclude by two things. First of all, to ask people who are interested in these issues to belong to Tax Justice Aotearoa and to follow our website and to join with us when we talk about beneficial ownership and trusts and other transparency issues. So please do take an interest and join with us in what we do. So that's the advertisement. Hope you won't mind. And secondly, and most importantly, Andres, thank you so much for giving us your time when you ought to be looking after your child or having dinner or doing other good things. Thanks so much for joining us and for giving us this presentation. I look forward to, if you could send us your slides so that we can put it up on our website and people can download it. I myself will want to do that, go over some of the intricacies of your positions. So thank you so much, and don't worry, we will be very willing to take up your offer of more further contact. So you don't have to feel that you're going to be ignored in the future, because you won't be, by us anyway. Thank you so much, and thank you very much for a very clear, erudite, and to my mind absolutely inarguable position about both beneficial ownership and about trusts, and the need to ensure transparency in taxation and asset ownership issues. So it's so important.